Welcome to the first part of a video training series on the conditional adult use retail dispensary, what we call CAURD. This video will review the different eligibility criteria for the CAURD license. We'll explain what the requirements are, discuss some common eligibility scenarios, and give examples of what kind of documentation you're going to need to submit with your application. Making sure that the retail dispensary you plan to open meets all of the CAURD eligibility criteria is the first and most important step in preparing to submit a CAURD application. Before we get started, a quick note: this presentation will be focused entirely on individual eligibility, rather than the eligibility of nonprofit organizations. Certain nonprofit organizations are eligible to apply for a CAURD license. However, the criteria is slightly different. For more information on nonprofit eligibility, please visit our website, cannabis.ny.gov/CAURD. To be eligible for a CAURD license, your planned retail dispensary must be majority owned and operated by at least one justice-involved individual who also has experience owning and controlling a qualifying business. These eligibility requirements are strict. They were designed that way to ensure that we are prioritizing individuals impacted by cannabis prohibition in New York State. We've also been asked about the business ownership experience. As you'll see later, any type of business is okay. What we're looking for are individuals with some experience successfully operating a profitable business. The third element that is required is a significant presence in New York State. Now, this sounds like a bigger requirement than it is. To have this presence, someone can live in New York State, own property here, have a vehicle registered here, operate a business here, or even have a bank account here. As we mentioned before, the first and most important step is to make sure that your proposed dispensary is majority owned and controlled by a justice-involved individual who meets the other requirements, like business ownership and significant presence. Now, that justice-involved individual must own and control at least 51% of the retail dispensary business, unless other justice-involved individuals are also owners of the retail dispensary business. We don't want people involved in name only. Justice-involved folks must be leading these dispensaries. If your proposed dispensary has more than one justice-involved individual, the total ownership of all justice-involved individuals must be at least 51%. In applications where there are multiple justice-involved individuals, only one of those individuals is required to have qualifying business ownership experience, but that person must own and control at least 30% of your proposed retail dispensary. So what does justice-involved mean? You've already heard me mention the term justice-involved several times now in this presentation. This is a term used throughout the CAURD regulations. It was created by OCM to capture the many different ways individuals may have been harmed by cannabis prohibition. Justice-involved is more than just someone who was arrested and convicted of a marijuana-related offense. It also includes the children, parents, and/or spouses of those individuals arrested or incarcerated. Does it have to be a conviction? Yes. In order to be justice-involved for the purpose of CAURD, we're talking about folks who have been charged or convicted with a marijuana-related crime. Arrests for possessing, selling, other controlled substances, things besides marijuana, do not make you eligible for CAURD. However, if you had other convictions in addition to a marijuana-related offense, they don't automatically disqualify you. The conviction or convictions that you or your eligible family members must have occurred in New York State, happened before March 31st, 2021, and be supported by documentation, which we'll discuss later. So what convictions count? As we mentioned, the marijuana-related charge conviction must have been a violation of New York State penal law. The most common laws, charges, codes that OCM will accept are Penal Law 221, offenses involving marijuana, which were appealed by the MRTA, and Penal Law 240.36, loitering in the first degree, and Penal Law 220, controlled substance offenses, as long as those charges are marijuana related. Remember that the charge conviction must be marijuana related. Whether it's loitering or a controlled substance, your documentation must include written reference of marijuana. If you or your family member have been charged or convicted of more than one marijuana related offense, you may submit information on multiple convictions. OCM will review the information on each conviction submitted and score your application based on the convictions that result in the highest possible score. So what convictions count? Here is a detailed list of all New York State penal laws, codes that may be considered marijuana related for the purpose of CAURD eligibility. However, if your crime falls under one of these categories but contains an element that would be prohibited under Cannabis Law Section 137, including but not limited to selling marijuana to someone under 21 years old, felony convictions for fraud, money laundering, forgery related to owning a business, or transporting, carrying, selling, or giving away marijuana, or offering to do any of those things to a minor, then that conviction would not qualify as a marijuana-related conviction for a CAURD license. So what if I plead to a lesser offense after I was charged with a marijuana-related crime? In the development of the CAURD license, OCM heard from people and communities across New York State. One comment that came up frequently was concern for the people arrested and charged with a marijuana-related offense who were eventually convicted of a different crime. Those individuals who were arrested for an eligible marijuana-related offense and eventually pled to a lesser offense may still be eligible for CAURD. If you or your family member were charged with one of the marijuana-related offenses listed previously and later convicted of a lesser offense, you may still be considered justice involved. In order to be eligible, you will need to submit your arrest paperwork that clearly indicates you were charged with an eligible marijuana offense. Just make sure you're able to prove that your original arrest and charge were for one of the eligible marijuana-related offenses. A marijuana-related offense is defined as a conviction of the New York State penal laws listed previously, or an arrest for one of those offenses that results in a conviction for a lesser offense as part of a plea deal. Now, Erin is going to talk about some examples of what it means to be justice involved.
Thanks, Damien. Now we're going to talk a bit more about what exactly it means to be justice involved. As we mentioned earlier, justice involvement isn't just the individual who is arrested and convicted. The war on drugs and marijuana prohibition caused damage not just to those individuals arrested and convicted, but to their family members and their community as well. In recognition of that, people are considered justice involved if they fall into any of these categories. Next, we're going to talk about each category of justice involved individual. We'll also give some examples of scenarios and determine whether or not these people are CAURD eligible. This is the most straightforward type of a justice involved person. If you are convicted of a New York State marijuana related offense before March 31st, 2021, you are justice involved. As part of your application, you'll be asked to submit documentation on your arrest and or your conviction. And if you've been convicted of multiple marijuana-related offenses, you can include those details on all of them as part of your application. Here's a story we heard at our community outreach. Ashley was smoking cannabis outside of a bar in May 2005 when she was stopped by a police officer and arrested for cannabis possession. Ashley was taken into custody and eventually charged with unlawful possession of cannabis in the second degree. Ashley hired a lawyer who was able to negotiate a plea agreement, and she was convicted of disorderly conduct and ordered to complete community service. Damien, does Ashley count as a justice involved for the purposes of the CAURD application?
Erin, absolutely. Because Ashley was charged with an eligible marijuana-related offense in New York State, she is considered justice involved. She'll have to provide proof of her original charge in addition to her conviction paperwork.
Here's a story about Phil. Phil was stopped by the police while driving home from a party in July 1998. When the officer approached his car, he noticed the smell of cannabis. The officer administered a field sobriety test and arrested Phil. Phil was later tried and convicted of driving while ability impaired by drugs. Damien, do we think that Phil counts as justice involved for the purposes of the CAURD application?
So Erin, as you can see, Phil never was charged with any of the eligible New York State marijuana-related offenses. Because Phil was never charged with or convicted of one of those eligible offenses, he is not considered justice involved. Even though his arrest was related to cannabis, he is not CAURD eligible because he was never charged or convicted of an eligible New York State marijuana-related offense.
Another way you may be justice involved is if your spouse was convicted of a marijuana-related offense. For the purpose of CAURD eligibility, spouse is defined as someone to whom you are legally married. Your spouse could have been arrested before your marriage or while you were married. Both count. You don't have to be currently married to a person with the marijuana-related conviction. If you're divorced or your spouse has passed away, you are still considered justice involved. What is important to remember is that you'll be required to submit documentation of both your legal marriage and your spouse's conviction. One important note for same-sex couples, because same-sex marriage was not legal in New York State until 2011, OCM will accept documentation of a domestic partnership between a same-sex couple prior to marriage equality. Here's Amanda's story. Let's take a look and see if Amanda meets the requirements for CAURD. Amanda and her longtime partner, Martha, have lived together since 1992, many years before they were legally able to marry in New York State. In 2002, they filed paperwork to be officially recognized as domestic partners. Prior to that, in 1997, Martha was arrested for cultivating cannabis and convicted of criminal possession of cannabis in the 3rd degree. Damien, does Amanda count as justice involved?
Yes, she does. Because Amanda was in a domestic partnership and that partner was convicted of an eligible offense, Amanda is considered justice involved. If Amanda applied for CAURD, she would need to submit proof of her domestic partnership in addition to proof of her partner's conviction for a marijuana-related offense.
Let's listen to Patricia's story. Patricia and Andrew were married in 2001. 2 years later, Andrew was arrested and convicted of criminal sale of cannabis in the 1st degree. Eventually, Patricia and Andrew divorced in 2012. Damien, does Patricia count as justice involved?
Yep. Even though Patricia and her husband have been divorced for 10 years, Patricia is still considered justice involved. Because Patricia was legally married and because her spouse was convicted of an eligible marijuana-related offense, she is justice involved. Remember, in order to be justice involved as a spouse, you will need to submit proof of a legal marriage or domestic partnership before 2011. Couples who live together and are not married are not considered justice involved for the purposes of the CAURD application.
Another relationship that would make someone justice involved is if your child or dependent was convicted of a marijuana-related offense. Again, the offense has to be an eligible offense, occurred before March 31st, 2021, and be a New York State-based offense. Just like the rules around spouses, for the purposes of CAURD, OCM is looking for people who can demonstrate via documentation that they are the parent through a birth certificate or adoption paperwork, or the legal guardian through guardianship documents and/or tax returns indicating that you claimed the minor as a dependent. Unless you are able to submit documentation clearly illustrating your relationship as a parent guardian to an individual, you will not be considered justice involved. Diana is a single mother from Syracuse. And in 2007, her 15-year-old daughter, Samantha, was arrested for possessing cannabis. Eventually, Samantha was convicted of unlawful possession of cannabis in the 2nd degree. Damien, does Diana count as justice involved person through her relationship with her daughter?
Aaron, the answer is yes. Diana's daughter was convicted of an eligible New York State marijuana-related offense, so Diana is considered justice involved. Diana will need to submit proof of her daughter's conviction, as well as their relationship as part of the CAURD application.
Terry is a married father of 3 from Buffalo. In 2005, Terry's adult son, Marcus, was arrested for selling cannabis. At the time of his arrest and conviction, Marcus was 25 years old and no longer lived at home with Terry. After going to trial, Marcus was convicted of criminal sale of cannabis in the 2nd degree. Damien, does Terry count as justice involved for the purposes of CAURD?
Yes. Even though Terry's son was arrested and convicted as an adult, Terry is still considered justice involved. It doesn't matter when your child was convicted, as a minor or an adult, where they lived at the time, with you or on their own. As their parent, you are still considered justice involved.
Another way to be considered justice involved is if your parent or guardian was convicted of an eligible marijuana-related offense. Much like other relationships, you will need to provide documentation proving your relationship as part of your CAURD application. In 1996, Jason's mom met her long-term boyfriend, Stanley, when Jason was 2 years old. Even though Stanley never married Jason's mom and didn't adopt Jason, he has been like a father to Jason. He's helped raise Jason and contributed to supporting Jason, paying rent and other bills. In 2004, when Jason was 10 years old, Stanley was arrested and convicted of selling cannabis. Damien, does Jason count as justice involved through his relationship with Stanley?
Aaron, the answer is unclear. Jason's situation is a little more complicated than the others we've already discussed. Even though Stanley isn't Jason's biological father and didn't adopt him, Stanley clearly supported Jason, and his conviction of a marijuana-related offense would have a negative impact on Jason's life. The key to becoming justice involved would be Jason including documentation proving that he was Stanley's dependent. He could submit tax returns where Stanley claimed him, proof that Stanley was supporting him the whole time.
Ava grew up in Brooklyn, where she was raised by her mom and grandmother. Ava's father, Freddie, was not present in her life growing up. She never lived with him, and he never financially supported her. In 1993, when Ava was 9 years old, her father, Freddie, was convicted of criminal sale of cannabis in the first degree. Damien, does Ava count as justice involved through her relationship with her father, even though they never lived together?
Aaron, the answer is yes. Even though Ava never lived with her father and he never financially supported her, Freddie is still listed on her birth certificate. Therefore, Ava is considered justice involved.
Another question we've heard a few times is, what about siblings? Having a sibling with an eligible marijuana-related conviction does not make you justice involved. Here's an example. Matt is the youngest of 3 children. In 1998, when he was 13, his older sister Allison was arrested for selling cannabis and convicted of criminal sale of cannabis in the 5th degree. Matt and Allison lived together with their parents at the time of her arrest. Damien, does Matt count as justice involved through his relationship with his sister?
Matt does not. While Allison's conviction would certainly have impacted Matt's life, it does not make him justice involved for the purpose of a CAURD application.
Chris and Andy are brothers from Queens. When their parents died, Andy became legal guardian to his younger brother, Chris, who was a minor. Andy supported Chris, and the two continued to live together in Queens. A few years later, Andy was arrested and convicted of criminal possession of marijuana in the 4th degree. Damien, does Chris count as justice involved through his relationship with his older brother, Andy?
Yes. Now here's an example of a sibling relationship that would count as justice involved. Not because they're brothers, but because Chris became a legal dependent of his older brother. Remember, this only counts if they are able to prove guardianship through legal documents. Now, if you have questions about whether or not your situation meets the requirements of justice involvement, first, carefully review the CAURD FAQs on the OCM website. And if you're still not sure, email licensing@ocm.ny.gov. Now, as we mentioned earlier, justice involvement is only the first part of CAURD eligibility. The next step is to make sure that justice involved individual also has experience owning a qualifying business. So let's talk about business ownership experience. The same individual who is justice involved must also have previous business ownership experience. Now, this isn't ownership of the proposed dispensary, the business you're actually applying to open. This is ownership of another business. As you'll see, that justice involved person must be able to prove they owned and controlled a business. If your non-justice involved partners owned a business, that isn't enough. If you ran a business, managed a store, or worked as the head of operations, if you didn't have an ownership stake, that experience won't count. Now let's talk about those qualifying businesses. Like everything else in the CAURD application, you'll have to submit documentation proving your business ownership experience. Now, this doesn't have to be a business that is currently open or a business that you currently own and operate, but it does have to be there. While having retail experience will be helpful in running your planned dispensary, it is not required to be CAURD eligible. Your qualifying business can be a retail shop, a restaurant, a barbershop, a hair salon, etc. Now, here are a list of requirements for a qualifying business. Remember, this isn't the dispensary you're planning to open. This is another business that the justice involved person has experience owning. What OCM is really looking for here is someone who has a proven track record of successfully operating a business. We want to know that this planned dispensary and the financial investment the state is making in this dispensary are going to someone who has experience running a business. We'll be looking for evidence that the justice involved person not only owned the business, but that they controlled the business. That means that they had leadership role and responsibility for operational decisions. So what kind of businesses count as qualifying? As we mentioned before, OCM is looking for business ownership experience. While we aren't flexible on that ownership requirement, we are flexible on the type of business that you operated. Ideally, we'd love to see someone with experience operating a retail business similar to a dispensary. We know that experience and those skills will translate well to running a cannabis dispensary. But we also recognize that many folks across the state come from different backgrounds, and we are willing to accept a range of business ownership experience. Now, Erin is going to take us through a few scenarios.
Here are some examples of business ownership experience that may not be as clear. Ben is a justice-involved person interested in applying for a CAURD license. For the past several years, Ben has been working as a rideshare driver for both Uber and Lyft. Ben manages his own time and schedule as a driver and handles his own finances. He regularly interacts with customers as a rideshare driver and has been making profits as a driver for the past 5 years. Damien, does Ben's experience meet the qualifying business requirement for CAURD?
Erin, absolutely. For the purpose of CAURD, we would accept Ben's experience as a rideshare driver as a qualifying business ownership.
Lily is a justice-involved person who's interested in opening a retail cannabis dispensary. About 5 years ago, Lily became a licensed real estate salesperson in New York State. Lily currently works for a real estate company representing both buyers and sellers. She manages her days, solicits her own clients, and receives commissions based on the sales she completes. Does Lily's experience meet the qualifying business requirement, Damien?
Yes, Lily's work as a real estate salesperson would count as a qualifying business for the purposes of CAURD.
How about Justin? Justin is a justice-involved person who owned and operated a bakery in Poughkeepsie with his 3 brothers. Each sibling owned 33% of the business. The bakery was open from 2003 to 2010 and was profitable for 5 of those 7 years. In 2010, the siblings decided to sell their business and have moved on to new careers. Justin now works as a nutritionist for a local hospital. Damien, does Justin's previous experience co-owning the bakery count as a qualifying business?
Yes, it does. Even though Justin is currently working somewhere else, he's met all the requirements of previous ownership. Now, he may have to do some digging for the paperwork, but his previous experience is just what we're looking for. So what is a significant presence? One final element that we're looking for in each application is that our justice-involved business owners also have what's called a significant presence in New York State. Now, this is a term you'll see commonly in many different kinds of licensure applications across the state of New York. To put it plainly, this means you either live in New York State, own property or assets here, keep your money here in a bank, or have some other connection to the state that we can document. Now, this is an important requirement for this application as it helps OCM make sure that those individuals or entities that have invested in New York State, either by living or setting up a new business here, or putting their trust in our banks, are the first to lead this new industry.
Let's talk about Amaya's story. Amaya lived in Atlanta where she began a small business. She moved to Rochester 3 years ago and continues to run her business remotely. She's also justice involved and interested in applying to open a retail dispensary. Amaya rents an apartment but does not own property or a vehicle in New York State. Damien, does Amaya meet the definition of significant presence for the CAURD application?
Yep. Amaya meets the requirement of significant presence for CAURD. She'll be asked to attest to that when submitting her application.
Anthony is a business owner who lives and works in New Jersey. He was arrested and convicted of a marijuana-related offense in New York State 15 years ago. He's interested in opening a retail dispensary in New York and opened a bank account on July 1st, 2022 to get ready for his dispensary. Damien, does Anthony meet the definition of significant presence?
Yes, he does. Anthony meets the significant presence requirement through his New York State bank account. Remember, it's having that bank account in New York State, not the fact that he was arrested here, that meets the significant presence requirement. So does it all have to be the same person? The short answer is yes. This is one question we've heard a lot of our community engagement events. The same person who is justice involved must be the person with business ownership experience and a significant presence in New York State. So that concludes the training on CAURD eligibility criteria. We hope you found this information helpful and feel more prepared to submit a CAURD application. OCM will notify the public approximately 2 weeks before the application period opens, so please connect with OCM and keep your eyes open for our updates. If you have more questions about the CAURD license, please submit them to OCM via email at licensing@ocm.ny.gov. Thank you.